afternoon, everyone, and welcome to Fridays with Keenan's Cutting Edge, where we discuss all things edge. My name is Jenna Labor, and I will be your host as we explore the dynamic world of Don Keenan's trial philosophy, The Cutting Edge. Those of you joining us live this afternoon are receiving early bird access to this episode. You know, you have the opportunity to ask questions and interact with our speaker. If you have questions, please type them into the comment section below so that we can be sure to address it. If you happen to be unable to join us live, episodes are released each week following the live broadcast. So be sure to hit that subscribe button and click the alerts icon so you don't miss an episode. Today, we have Michael Reiter with us out of Maryland. Mike is going to speak to us on what to do when you're in a jurisdiction that does not allow attorney-led voir dire or has very limited attorney-led voir dire. Voir dire, or jury selection, or voir dire if you're from the South, is one of the most critical parts of trial because the jury will be making the most important decision in your client's life. And you need to be able to know and trust the folks on that jury. Being from a state that allows about 20 to 40 minutes of attorney-led voir dire total, I know the struggle of having to tailor edge jury selection techniques to a very limited time, but not to the extent that Mike and some others of you do. So Mike, tell us how you use edge voir dire teachings when you have little to no attorney-led voir dire.
Thanks, Jenna. Appreciate the opportunity to speak about a topic that I'm confronted with every single time I step into the courtroom for a jury trial in Maryland, and that's the fact that we really don't get attorney-led voir dire. And so let me start by saying the long-term goal in Maryland is to be able to get attorney-led voir dire. That would absolutely be a game changer. Bar none. There's no substitute for that. I am lucky enough to practice in Virginia, where we do get attorney-led voir dire. Also unlucky to practice in DC, where we don't. And so I just wanted to start the discussion by saying that, listen, at the end of the day, we're pushing. I know there's neighboring jurisdictions like Massachusetts who have recently gotten attorney-led voir dire. And so, there's no way around it. It'd be a game changer. There's no substitute. But here's the good news. That's not the end all be all. So even though it's a long-term goal, in the short term, we deal with what we have. And so another thing I want to address and kind of tackle as we go on through the podcast, and I'll address this in more depth at the end, is it's always important, as we know in the edge world, and Papa Don has burned this into my brain too many times to count. And that's the importance of being prepared. Having a plan A, a plan B, a plan C, a plan D. When something gets closed, go in the other door. And so we always want to have our ducks lined up. And one of the things we can do is have an evidence brief in these jurisdictions like Maryland, DC, others where we don't get attorney-led voir dire. Make sure you've done your research, filed a brief in advance, be prepared with the brief at your fingertips for what the bounds of what you should be permitted on voir dire. And also, believe it or not, there is a mechanism in Maryland, where I do a lot of my practicing, to be able to request attorney-led voir dire. Never had it granted. Judges are not very in tune with permitting it, but it's part of what you can address in your evidence brief. And even if you don't get it, what you're ultimately going to have the opportunity is you're further educating the judge so they're not ambushed, so they understand, what is and what isn't permitted. And what it ultimately may allow you to do is have some more leeway in what you do want to get into in voir dire. So why are we really here? I've told you about how we want to get attorney-led would be a game changer. I've told you about you can file the brief, but it may not, be permitted. And more often than not, it's not. But as we all know in the edge world, it is critically important to be the woodpecker. And we all know what the woodpecker means. Papa Don's told us countless times. It's when one door gets closed, you go in the side door, you go in the back door, you don't take no for an answer. So in these jurisdictions where we don't get attorney-led, you could sit there and feel sorry for yourself. you could be discouraged, or you could, again, deal with the cards that you're dealt and plug away and find a way to maximize everything you can out of attorney-led. And the card that we're dealt, as we know, and I'll use Maryland for an example because that's where I practice a lot, it's that the card is judge-led voir dire. And so what I really want to do today is talk about some of the things you can do to be the woodpecker, to not take no for an answer, to maximize the juice that you can get out of attorney-led. And then also, to talk about not only some of the little things you can do, but big picture things that you should be looking to accomplish every time you're dealing with attorney-led voir dire, and so that you can maximize the juice out of the questions that the judges are going to be asking for you. And so in addition to some big picture things that you can use to tackle, I also want to spend some time going over some specific type questions and topics that I've been able to that myself, and my firm have been able to successfully utilize over the years. And let me say this too, and this goes to the edge in general. It's a collaborative process. So you can't do this alone. It's never stagnant. It's never static. So we've crafted questions, we've edited, re-edited, adapted, depending on who we're dealing with. And I think that's only getting started. The hallmark of success is making sure you're constantly adapting and revising. We've really tried to hold true to that. And listen, there may be a ton of questions that we're not even thinking of that we can ask. That's one of the benefits of collaborating with other people and kind of pushing the envelope. So a couple things to think about from a big picture, systems level perspective when you're doing these questions. And for one, we talk about POV or point of vision or point of view all the time. If you don't think about your specific judge's POV before you submit your written voir dire, you're missing a huge opportunity. So for one, you want to make sure you're doing your due diligence, doing your research, know who your audience is, because that's, as we all know, whether it's a witness, whether it's a judge, we got to know the most effective way to communicate with them, but we got to know what's on their blackboard or their bulletin board ahead of time. If we don't do that, we're missing a huge opportunity. And so the way that it typically works, depending on which county you're in, but for most of them in Maryland, is you submit written voir dire questions for the judge's consideration. A lot of times we don't know who our trial judge is going to be until a couple days before, sometimes the day before, sometimes the morning of, which, as we know, one of the hallmarks is also doing your research and your due diligence ahead of time. So if you know what jurisdiction you're in, which you will, make sure you look up the various judges, make sure you know their tendencies, their inclinations, make sure you know the best way to communicate with them, because you may have to make reactive decisions quickly. But one of the things I've noticed with virtually all the judges in Maryland in terms of their POV is, at the end of the day, they want to rifle through and get through this jury selection as quickly as they can. There's no way around that. So you can either acknowledge that and be aware of it, or you can ignore it. If you ignore it, that's a fool's errand. So if you know that and acknowledge it, what's the best way to communicate with them? Well, we've seen over time, when you do an evidence brief, which we've touched on briefly, that's going to start to educate them. And what judges don't want to do, I try and start with the premise that, they're going to listen and give you an opportunity to educate them and try and do the right thing. If we give them the ammunition they need to know why they should do a certain thing, we're going to be on good footing, and we're going to have an opportunity to do, or at least have an opportunity or a chance for them to consider what we want to do. And so knowing that they want to get through things as quickly as possible, but knowing they want to do things correctly, have your authority, have your citations, have your evidence brief done well in advance, so that they don't feel ambushed. The chances of you being able to get more rope and more leeway, I'd say, are exponentially increased if you've done your legwork ahead of time and the judge doesn't feel ambushed. So what do I mean by do your homework? Well, when you submit these written questions, again, be role playing, be thinking out in your head, what questions, what issues are they going to have? What can I do to make sure they're going to ask the questions that I want? So if you have a specific citation, whether it's case law, whether it's a pattern or non-pattern jury instruction that you think might support your submission, have that ready at your fingertips. Don't be fumbling around. Don't say, Your Honor, I just think it's a question that I should be able to ask. Be ready and be prepared so that you can provide them, not just the authority you want, but the cover they need to understand why it is permissible and why they should be able to ask certain questions. Aside from case law, aside from jury instructions, one other place that we've kind of mined for, which helps us in a number of areas, is make sure you watch your local juror orientation video. There may be additional things that can help you in there, not just, during jury selection, but in opening and closing. It's a treasure trove of good things. And if there's a citation you can put in there, great. So for one, have the authority, be bulletproof for why you think you should be able to ask a certain question. And, again, don't get them caught off guard. Don't blindside them. But even better, if you have an opportunity to write things down, even more reason they won't feel ambushed, because they'll have a chance to review things. And the way that it typically works is before they bring out the jury, they're going to have an opportunity for counsel. They're going to go through the questions, say, here's what I'm inclined to give. Here's what I'm not inclined to give. And there is a wide range of discretion. But what we've found is if the questions where, there's some questions they're always going to give. There's some questions you have a pretty good sense they won't, but there's some that are more in the borderline area. And if you can sway them and persuade them, that can make all the difference in kind of persuading and priming as you try and make your case and go through jury selection. And so when they go through that initially with us and with counsel, just everything I've talked about, be prepared and be ready to articulate. And this is kind of goes hand in hand with the evidence brief, why the question that you would ask would be ripe to lead to a strike for cause. If you can articulate that to the judge, what I've found is they are a lot of times receptive. Even if there's a question that's outside the box that they don't normally hear, they're willing to at least consider it, as long as you can give them a good faith basis for why you think that question could lead to a strike for cause. So those are just some kind of big picture items. And then in terms of format wise, typically what most of the judges do in that jurisdiction is they will go through, but then they'll ask people on a note card. Usually they don't have the answers from the gallery, but they'll go through a note card and then they'll ask each juror to come through one by one to the bench. And I'll go through some additional tools that you can get to have a little rope to actually do some follow-up yourself, even when the judge is guiding and kind of leading that conversation. And so just to review a little bit of what we've kind of touched on, be prepared if there's a certain jury instruction that supports what you want to ask, have that ready to go. One of the targets, the big picture things that you want to be thinking about when you go through is find and strike the rats. You should be mining for them. Find and strike the shit happens jurors. We've heard all about that over and over. And that should be one of your targets. Be thinking 5 steps ahead when you're crafting your questions. What am I going to do to achieve those kind of big picture system level goals? Another thing, and I kind of touched on this briefly, the concept of embedding. So even if you don't get to ask a question in the exact format that you want, if there's a certain type of area that you want to embed in the jury's head that you're going to go back to an opening, that you're going to dovetail and go back to during the course of trial, that you're going to dovetail and go back to during closing, make sure you think about some of those things that you want to embed to at least start to imprint and get that concept on the juror's blackboard. One example that comes to mind that we deal with, in all of our cases are medical attitudes, right? Doctors don't spend enough time. Doctors don't run the right tests. Doctors don't care, don't communicate. These are things that you can kind of look into and try and find out what is the POV of your jurors, things that you can come back to and use during the course of jury selection, but later on throughout trial. So I think that's critically important. Another area where I would say that's really important to brief ahead of time and to really be prepared to go at, which isn't always easy, but critically important, is preventing juror rehabilitation. So do your research. There's cases on point in virtually every jurisdiction. One of the things we've looked into and kind of briefed ahead of time, and you can put a memo on this, it's improper for the court to rehabilitate by asking the juror whether the juror could be impartial, because it's improper to shift responsibility to the prospective juror to decide the prospective juror's bias. So I'm sure we've all been there, when you approach the bench, at least where we practice, and you have a clear inkling that this is someone who's biased, that, clearly is someone who should be stricken for cause. And then the judge goes out of their way, to go above and beyond to rehabilitate them. Well, if you're just kind of talking out of your butt, for lack of a better word, and you don't have the authority that says, hey, that's not improper, you're not going to be on the good footing that you want to be on. But if you've kind of briefed that issue ahead of time, essentially put, the trial judge on notice, potentially have a deterrent effect that, at the end of the day, this is improper. And so I just want to alert you. And then, listen, if it really is something that happens, then, you have to be able to willing to tactfully, object if necessary. It's really critically important. And then, what you really want to lean on is when a juror, in those separate private sessions, when there's any inkling or indication there might be bias, what I have found a lot of judges will allow is attorney follow-up. And that's your opportunity. Don't shy away. Don't be afraid to ask questions. Don't be afraid to be the woodpecker. Push the envelope. And if you think someone you need to eliminate and who, clearly there's a basis to strike for cause, then push the envelope, and until you're shut down. And at the end of the day, if that's a strongly held belief, if that's a core value that they can't put aside, you can do that, and you can achieve that and do some rat killing on your own, which can be critically important. So juror rehabilitation, if you haven't briefed it in your area, do it, but it's something that I think can have a big impact. Another thing, that can be scary when it's mostly judge-led jury selection is what I call the quote unquote silent killers. So those are those scary jurors who don't say anything. And, when we get the juror list, that's another thing we don't get in advance, unfortunately. We typically get handed to right before they bring out the jury. But, you'll have occupation, you'll have age, you'll have spouse's occupation, you'll have level of education, you'll have where they live within the county. And when you do that, one of the things I have found that a lot of judges will permit is if there's missing information. And so whether it's occupation or one of the other categories I just went through, you can politely ask, say, Your Honor, respectfully, we haven't heard anything from them. I would at least like, an opportunity to find out this information that they've omitted, that I think we're entitled to. And I can't remember ever not having the opportunity to do that. And so I think that is another area where you should push for. And here's kind of the added benefit. When you push for that and they get somebody up there, what typically happens is something else will come out. You'll say, well, now that I think about it, I might have had a responsive answer to one of your other questions. And then all of a sudden you got a little additional information. And when you're dealing with rifled through, I think getting as much information, just getting them talking can be really valuable. So that's just another big picture, thing. And then, we've touched on this, but everything you do, and there's case law to support this in terms of the purpose in Maryland, be able to provide on your feet why that would lead to a strike for cause. So that's what I've found on those questions that judges are willing to consider. That's kind of been the tiebreaker where I'm able to articulate, or where, other members of, throughout the bar have done this as well, which is you're able to articulate why it is that specific question would lead to a strike for cause. So I think that's really helpful and valuable. Another thing when you're thinking about embedding in your case is, from an edge perspective, there's certain things that you're going to want to accomplish, and be thinking ahead of time, in the questions that you craft, in the questions that you draft. Are there certain codes that you may want to embed? We've talked about POV, how can you embed POV within the questions that you draft and craft? Is there a way within the questions that you're providing that you can get at other analogous systems, where you have different jurors from all different walks of life, where you're gathering that information? What can you accomplish from a big picture perspective? And be thinking about all that, when you're drafting things in the first place. And so going back to where we started, the POV of the judge, sometimes what will happen is, the judge will say, well, counsel, I'm willing to consider giving a question like that, but not as you've phrased it. Well, knowing what their POV is, which is, to get in and get out as quickly as they can, but to keep an open mind. You want to make sure not only that you have authority at your fingertips, but that you're willing to work quickly to recraft a question if necessary. And that's another part, being the woodpecker. So be thinking ahead, have a plan A, have a plan B, have a plan C, have a plan D, if they allow this topic area, but they won't allow it exactly how I've crafted it. Be prepared to work on your feet. We got to be able to handle things. Papa Don tells us as the bullets are flying. When the bullets are flying, you got to be able to quickly recraft and see if you can get the judge to give it that way. And that's part of being the woodpecker. If you can't do that, if you say, I appreciate that, Your Honor, can I have a few minutes to talk things over and see if I can recraft it? Then you're sunk. They're not going to consider it. You're going to get the immediate push of the jury. The jury's waiting. Come on, let's go, counsel. So be prepared and be ready to kind of recraft and redraft so that you can get the juice that you need. And so I want to kind of shift gears a little bit now. And I said at the outset, I'd go into some specific areas that we try and target and that we have had success in different judges, given over and over. And one of those is, I can't remember the last time I tried a case with my client in the courtroom. So client out of the courtroom is a question that we've been able to get judges to give over time. And what it really boils down to, is kind of educating them that they're going to be out of the courtroom for various reasons, and then seeing if anyone would hold that against your client, anyone, would have issues. And as we learn, you want to ask for permission. And so that's an area, where I think, again, by being the woodpecker, by them seeing this over and over, where they understand, that is a critical area of inquiry, and we should have an opportunity to dive into that. And so we have had success with that. But I'll also say, not always. So what does that mean? Well, be the woodpecker, have done your focus groups ahead of time, have looked into whether, that think that's going to be acceptable and permissible. And if one door gets shut, I have had times where I had a pretty good feeling based on the legwork we had done ahead of time where, they'd be okay with it, but you never want to go in blind. So one of the things I've had a chance to dovetail and do an opening, say, listen, Ms. Smith is not going to be here during the course of trial inside the courtroom. Now, that's not to be disrespectful or rude to you. That's not because she doesn't care. She's going to be right outside the entire time. But there's some reasons why it's difficult for her to be in here. It's difficult for her to have her name dragged through the mud. It's difficult for her to hear people who are close to her talk and discuss about how she's changed. It's difficult for a host of reasons. And we hope that's okay with you. She sit outside. And I've been able to interact with jurors, and on tons of occasions, you'll make eye contact, you're kind of interacting. We talk about the importance of body language all the time, kind of a head nod. So we get it, we understand. And so, obviously door A is better, but you got to be creative. You got to, when one door gets shut, go to the next door. Another area where we've had a lot of success is, again, I can't remember the last time where we actually claimed medical bills or wages in a case. And so one of the questions we've been able to ask, and kind of give you an example of this a little bit, is to kind of flesh out for anyone and educating the judge. And I'll read it and I'll kind of give you the analysis afterwards. But one of the types of questions we've been able to ask is, does any prospective juror believe that a person who brings a claim for money damages for injuries suffered in a collision believe that only compensation for lost wages and medical expenses may be allowed? Counsel requests leave to ask follow-up questions. And then, there's also different variations of that. So I talked at the outset about the importance of having your jury instructions lined up, having the authority and support for doing what you want to do. And so, a slight variation of that, again, if you get shut down, or if you want to craft it in a little different way, does any prospective juror believe that it's wrong to allow money damages to compensate an injured person for non-economic damages other than medical bills, such as physical pain and mental anguish and inconvenience? And that language, physical pain, mental anguish, inconvenience, that goes directly to the pattern jury instruction. So I can say to the judge, Your Honor, respectfully, I'm not pulling that out of thin air. This directly tracks the jury instructions. And most importantly, if there's a response to that says, hey, I'm only willing to give money, dollar value for medical bills and wages, but not for the non-economic, not for the intangible, not for the specific things that are laid out in the jury instructions, then what they're really saying, Your Honor, is that they can't and will not follow the law, which, as you know, is absolutely a basis for a strike for cause. And, we've had a ton of success with that. And what that ultimately allows you to do too, is even if you don't have, and you're not able to kind of generate the nice crosstalk that you would if the attorney was guiding it, what you've kind of done is you've primed the pump, you've embedded and kind of given them a sneak preview of where you're going to go. And you can dovetail that, an opening, you can dovetail that in closing and kind of remind them of what they said when they all took an oath to do their job and do the truth, and remind them that what they're here for is not to be human calculators. If we just needed them to punch a couple buttons, type things in, crunch some numbers, then we really wouldn't need a jury. But we need them to do a whole heck of a lot more than that. And we need them to do what they're uniquely qualified to do as human beings, and that's put a value on health and human happiness, or however you want to phrase it. But you see how the legwork you're doing up front, and this is all stuff you can do with judge-led jury selection. So again, don't be discouraged. Keep kind of pushing the envelope. And another thing that I've noticed is, one of the things we always learn about the edge is always adapting and always kind of reinventing. And if you can do something better just because you've had success with it in the past, autopsy it and try and do it even better the next time. And so one of the good things, believe it or not, to come out of COVID is, I've had a chance to try a few trials, even, post-pandemic, where we've been able to get in the courtroom. And one of the things that's happened is, at least in Maryland, in a lot of the counties, they're doing Zoom voir dire, and they're dedicating, a number of hours on a completely separate day from when you start the trial. And the way that it was typically done before is everything would be done on the same day. You'd come there, you'd do the jury selection from the outset. Well, what's happened now, and what I've noticed, is when this gets set ahead of time, you're usually getting the juror list ahead of time. You're also getting, many hours blocked off in a day where not everyone is feeling so rushed, where I've noticed the judges are more willing to consider a wider base of questions. And so, we've used that as an opportunity to kind of show them. And I think it's been valuable, some of the benefit or value to really having an extended, jury selection and voir dire. And that's been a huge benefit, in a few different cases where you get this longer Zoom. And the way that it's typically worked is you'll get the whole panel there at once, and then, there'll be a separate breakout room where they take the juror in one by one. Now, of course, we'd love to have everybody there for crosstalk, but again, be the woodpecker, take what you can get. And what it does, and what I've noticed too, is, there's been even more leeway for follow-up. A lot of times it wouldn't necessarily be on every single one that comes up, but, you're really able to get some more leeway. And so take that, and run with it. And even with the judge kind of running the show, an opportunity to jump in and kind of ask some of your own questions, and don't go in blind. Assume that you're going to be able to do that. So practice it ahead of time, role play it with colleagues, role play it, with other people that you work with, because you should assume, in these areas that, you'll be able to have a little more rope. And I think one of the positives that's going to come out of that is a lot of judges are going to see the value of really getting and knowing something about your jurors, and that attorneys are very much capable of handling the questioning. And so I think it's only going to help with some of the longer term projects. So another area where we've been able to embed is safety policies and procedures. So a couple different variations that we've been able to ask. For one, does any prospective jurors believe either that companies must always have safety policies and procedures, or that it's never necessary for corporations to have safety policies and procedures? Again, you're kind of embedding this concept. You're going to have safety rules in your case. You're going to have safety systems. You're going to have safety policies and procedures. And so you want to start to ingrain the concept and know who, is involved in that and who isn't. And most importantly, ferret out, your shit happens jurors. You want to make sure what's going on. You want to make sure the rats. You want to make sure what's going on ahead of time. And so there's other variations and questions that you can ask. You can also, what I think is helpful, to find out what's on people's POV, and so anyone who's actually been involved in actual rule making or policy making, or safety systems, understanding the right way to do things, the wrong way to do things. Is, has any prospective juror created policies and procedures for preventing trip hazards and for providing warnings of trip hazards? If that's, kind of what's relevant, or the topic area in that specific cases, you can probably guess it was there. That's a question we've been able to ask. Same deal. Does any prospective juror have experience in creating safety policies and procedures and enforcing those policies and procedures for businesses? I mean, you want to know that going in, and you want to start to embed that concept. And if someone says, maybe these are just optional, or I don't think they're that important, you may be able to get strikes for cause, but at minimum, you're going to be able to intelligently exercise, your peremptory strikes, and you're going to know who your rule followers are, and who they aren't. And I think that's, really valuable and really important. Again, that's just another topic area where we try and hone in on. And, what I'm trying to do is give you a sense of all the different areas where we've kind of laid out in a number of cases. There's obviously case specific. For example, you may have a specific type of premises case involving inadequate warnings. You want to hone in on that to find out POV. You may have a medical malpractice case where there's a specific type of area that you want to look into. This is not by any stretch a one size fits all. So, you got to look at each case individually, but there are things from a system perspective that you can utilize, over and over. Another thing that we get into frequently, and I'm going to give you a few different variations of how we phrase this successfully, is tort reform. We hear about it all the time. We know about different stools and we know what it is. And we know that we want to know, what's on our potential jurors' blackboard. So, one of the things where we'll get some leeway is, some of you may have opinions about whether there are too many or too few lawsuits, or about whether people who sue get too much or too little money, or about whether the rules concerning lawsuits are fair, either to people who sue or to people who get sued. Well, go on to say, the jury's responsibility is to decide what the facts are in this case alone, and to decide those facts according to the legal rules that I will explain to you. My question is this: do you have such strong feelings about lawsuits in general, either positive or negative, that it would be hard for you to follow my instructions on the law, to decide the facts impartially, or to be fair to both sides in this case? And that's actually from DC, which, like Maryland, is judge-led. And, that is straight from the case law. And that does give you a good sense of what's on people's blackboards. And it is important to know that, because I've had jurors, when they approach the bench, and this one was from a recent one and really stuck out clearly in my mind. One of them said, listen, I hear about this jackpot justice and I'm just not, going to stand for it. Well, you want to eliminate, that rat, if that's what you hear, and you need to ask those questions and push the envelope to make sure the judge is going to give it so you can make an informed decision at the end of the day. So that's another area, where we've had success. We'll typically ask in the area of claims adjusting as well, and anyone ever been trained or in a position that require them to investigate or adjust claims for personal injury. That'll give you, a bird's eye view. And again, we kind of map things out through focus groups ahead of time. And just because you're in tune with, what someone's job title or description is, you don't always want to assume something. So you want to be careful about striking someone who you might otherwise want on the panel, but think about, asking those questions. That's going to give you some valuable insight. It's going to help you understand, where they're coming from. And that's something you want to know in every single case. Same deal, a question that we've had plenty of success, and I can't remember not being allowed to ask this. And that's about, anyone who's got any experience, ever been employed in the field of risk management, store safety in a retail sales environments. That was for a specific case where we were able to ask that question. But it's really helpful, to find out, again, these are all things that go to, do you have rule followers? Do you have people who understand the importance of safety rules, policies and procedures, enforcing that they're actually followed, so that we don't have danger all the time, so that, foreseeable dangers are in fact prevented? These are all questions that, you're not going to be shut down from asking as long as you craft them the right way, and as long as you're prepared to make sure you notify, why that could lead to a strike for cause. We always ask, questions about any experience in the legal field, any experience in the medical field. And that's because we want to know, in terms of what knowledge they're bringing in, again, what's on their blackboard, their POV, and also their views of the medical system in general. They're going to understand, some of the challenges that are faced. Maybe it's not so simple to never miss an appointment. Maybe it's not so simple to get in for a doctor's appointment. Maybe there's good reasons for a referral. So, you could ask, formulated any opinions about our medical system based on their own present or future medical care relationship with the medical profession. Again, that's going to give you ideally some valuable insight, and again, help you embed some of the different things from a medical perspective that you want to be able to do, so that what's on their blackboard. And so that when you come back to it, you're probably sensing a theme, everything's a symphony. So an opening, throughout trial and closing, it's not the first time they're hearing that. And what I've found is, even if you don't get any responsive answers to some of these questions, just kind of having that concept and embedding those things out there so it's not completely foreign will help you during the course of trial. Another area, where we always get into is previous claims or injuries. I'm sure that won't be a surprise to any of you. That's probably pretty routine, but I think it is really important because, again, if you have a case, that involves an aggravation or susceptibility to injury, you want to know what they're thinking about, and you want to set up for when, you talk about things from a systems level perspective later on. If you've got someone with an aggravation or someone who's more susceptible to injury and they've kind of heard, and you've heard what's on their thoughts, in jury selection, you may be able to use some of that later on. Well, listen, when you look at the jury instruction for aggravation, or you look at the jury instruction for special susceptibility to injury, we don't live in a society where we shut our courthouse doors to people who didn't have an entirely clean bill of health before coming in. And that's not the way that it should be. And that's a good thing. And you see how, something you may say in closing like that, you've teed it up from jury selection and you've started to embed it. Another area that we always try and flesh out in jury selection is emotional component or emotional damages. I think too many times in our cases, you'll of course probably ask if there's any similar injuries from a physical perspective to what you have in the case, but don't ignore the emotional component, especially if you have psychological or psychiatric care, because as we all know, sometimes physical injuries do in fact heal, but you can't erase memories, and emotional injuries may be there forever. And that may be the more powerful damage or issue that they're going through. And if you haven't asked that, if you don't know about that, then you're not going to be able to effectively address that. And so that's really important and really critical to make sure you tee up and go over. So, make sure you dive into that, because if you don't cover that area, you're going to be missing a huge opportunity. Other thing, that we'll ask about is we want to know if they have any problems, serving as a member of the county, of the community, of the society, and rendering a verdict in that case. And there's, again, we talked about the juror orientation video. So you can pull the language directly from there. Does any prospective juror have core values that will make it impossible to meet their responsibility of being a citizen and serving the community by being a juror? We want to know that early on. We want to embed the absolute importance of serving on a jury. This is, all jokes that they may have about jury service aside. I mean, this is something that's important. Is this a responsibility that you're willing to accept? Do you understand the gravity and the magnitude of what's involved in that? And so, you really want to make sure that you address that and that you have that teed up. Same deal. Any strong beliefs that would prevent you from serving as a representative of the community and reaching a verdict based on the facts which are presented in the law you're taught by the court. You want to embed the importance of following the law, of following the rules, because rules apply to everyone, right? They apply to your specific case, but rules apply to jurors as well, and they took an oath. And so you want to impress the importance on that. Another area we really like to get into is what I guess I would call the lawyer code. And, we'll ask a question a lot of times, for example, does any prospective juror have a family member or close personal friend who's expressed strong negative feelings about lawyers? And that way you're opening it up, not just to that individual juror, but, close family members. And they say, well, it's not mine, but I've heard this. Well, we want to know that, right? We want to know if anyone's so predisposed, so, jaded by the system itself, or, if they'd have had an incredibly difficult experience with an attorney. I mean, we do not want to go in blind by that. And the other thing that allows you to do to know what's on their blackboard is give yourself the opportunity to earn their trust, to go off code, to make sure, well, listen, I understand that. And maybe someone's just being open and sharing and kind of, making you aware of that. But that may be an even more powerful, potential juror because they've seen the bad side of it. And now if you're able to effectively earn their trust, if you are not what they expect, if you're not a liar, if you're someone who they can trust, who's true to their word, and who sticks to their word during the course of trial, I mean, that can be an incredibly valuable, powerful tool. And then other areas, again, follow the law. That's another topic area you can address. You can address their core values, strongly held beliefs, and the overarching principle and concept associated with all these is that, at the end of the day, being able to describe and articulate why something like that could lead to a strike for cause is going to be incredibly valuable. And I think if you stick to all these concepts and then you build upon, listen, this isn't the end all be all, have something better, share it with me, share it with the group, collaborate. But I think this is a great kind of, from a systems level perspective, an opportunity to get as much juice as you can out of jury selection, and again, not get discouraged by some of the limited things that we may have. And so I said at the outset, I did want to talk a little bit about the evidence brief, and I do think that's important. So, one of the things that you want to have teed up, and again, one of the cool things about collaborating is I can't take credit for all this. We have local listserv where people share all the time. We have briefs, and then it gets built upon. And so, one that was previously shared talks about the specific rules. So believe it or not, Maryland Rule 2512D gives the court the authority to permit the parties to conduct an examination of qualified jurors for purposes of challenging an individual qualified juror for cause. And then there's another case that stands for the proposition. This is Washington versus State. The core purpose of voir dire is to ensure a fair and impartial jury by determining the existence of cause for disqualification. So this goes back to where we started, being the woodpecker. If you don't ask whether you can have the opportunity to conduct it, you can't be told no. And last time I checked, no one's ever been kicked out of the court or held in contempt for being told no to something. So if you don't ask, you can't be told no, and there's no reason not to push. And I think the more we all push and follow these, I think even, you find the right judge who allows more discretion, more rope, you may get an opportunity. It's the way that we keep chipping away. And even if you don't get full-fledged attorney-led, part of the benefit is educating and kind of not ambushing and telling them, what leeway we have. And if nothing else, that may buy you an opportunity for more leave to follow up It may give you more rope for different areas of inquiry. So there's a whole host of reasons why I think it's beneficial to do that. There's another case, that gets cited in the brief. It says, Court of Appeals has made clear that this court will prescribe the juror voir dire process as is necessary to uncover disqualifying bias. Again, going back to where we started, we are supposed to have an opportunity to engage in meaningful jury selection so that we can ultimately understand, not just for us, and this is another thing you can do, quid pro quo, it's not only beneficial to the plaintiff, but it gives the defense, an opportunity to engage in meaningful jury selection, which helps everyone because we're going to have more fair and impartial juries if we're allowed to participate in a meaningful process. And you got to keep being the woodpecker. You got to keep, chipping away at that. And other topic areas, aside from, like I just said, saying the rule itself explicitly authorizes, the attorney conducted voir dire. You can also, there's a concept and there's empirical studies and there's all sorts of attachments you can include, but I think it is, beneficial to share with the court those studies that say attorney conducted voir dire is more effective at unearthing juror bias through the reciprocity effect. And, at the end of the day, kind of embedding that concept and kind of helping understand the value and the importance of letting the attorneys participate is only going to make your ability to do that stronger. And even if it's getting additional opportunities on a single question, that question might be absolutely critical to having the jury that you want for that jury trial. Another area where you can ultimately jump into is going back to knowing what's on the judge's POV, which is get through this as quickly and efficiently as possible. I got jurors waiting. We got to get them impaneled. Well, if you can explain to the court that based on all the studies, allowing attorney participation in the process is not going to, exponentially or unduly or in any way extend the process, that's really valuable because that's what they're thinking. Well, this is going to take forever. This is going to take hours or days on end, which is why I think it's even more important to push it in this Zoom climate that we're dealing with right now. But even more so, laying that foundation. Again, even if you don't get the entire gamut of what you want to do, they'll understand allowing more ability to follow up or more inquiry, in general. It's not something that's going to drag the process out for days on end. It's going to be a slight bump or increase. And if it leads consistent with the case law and consistent with the purpose to a more fair and impartial jury, then, they're doing a disservice. And you want to start with the premise that they do want to try and do the right thing. And then also you can cite to Court of Appeals decision about the importance of conducting the process in a more effective method. It's at the end of the day, it's their responsibility, constitutional responsibility, to remove potential jurors that cannot be impartial in following the court's instructions. And so at the end of the day, we talk about quid pro quo all the time. We talk about rights. Well, I think we have a right to know that we have the ability and the opportunity to engage and conduct meaningful voir dire. And here's some encouraging news. Even if certain things get shut down, dovetail, find a way to get them in opening. But I've actually had an opportunity recently, which was encouraging in federal court, where one of the judges was open to the possibility of, at least for certain questions or for a certain period, allowing some entirely attorney-led jury selection, which, is encouraging, which means they're thinking critically about it. And if you get that opportunity, take full advantage of it. It's going to be an ongoing collaborative effort. for now, we deal with the cards that were dealt, but dealing with the cards that you're dealt doesn't mean rolling over and not pushing the envelope and getting as much juice as you can out of it. It means doing everything you can to get the most informed, most comprehensive work you need to get a jury. And I'll kind of leave you with this, which is, we always got to adapt. We always got to collaborate. We always got to be creative. Just because some of this stuff works doesn't mean it won't get shut down later. And so we may need to rephrase and reframe, which is completely fine. But there's also things that we're probably missing that we can keep pushing, always evolving and always trying to do better and, never get stale, never get stagnant, continue to collaborate. And I look forward to hearing and working with all of you to see how we can continue to do things better. So I don't think I see any questions. If there are any, happy to take that now. If not, I really appreciate, the opportunity to talk to all of you, and as we continue to collaborate and push together to try and get more than we can. So thanks, everybody. I really appreciate it. Thanks for.
Thank you, Mike, and thank you to all of you who joined us live for this week's episode of Fridays with Keenan's Cutting Edge. If you liked today's episode, please click that thumbs up button and don't forget to subscribe and click the alerts icon so you don't miss the next one. Next week, we'll be hearing from Devin McNulty out of Texas as part of our Superstar series. Devin and his team achieved a superstar-worthy result in a recent case down in Texas, and we'll be sharing how the EDGE method helped him get justice for his client. I can't wait to hear what worked for Devin along with all of you. Have a wonderful weekend, and I'll see you next time.